All right, certificate conductor certification rule final ruling. Um, S. Review Board, the Brother Locomotive Engineering Training Union and the United Transportation Union commented on the OCRB should be compromised. At least three members, and one of the members should be an attorney. As stated in the notice of the provision of rulemaking for the creation of the OCRB will require issuance of an internal FRA order. The makeup of the OCRB will determine that order. However, the FRA expects the OCRB will mirror the makeup of the Locomotive Engineering Review Board, which is currently used in the FRA to adjunct dispute, and under the part of 240, the FRA expects the FRA attorney will serve as a counsel for the OCRB, just as they did for the Locomotive Engineering Review Board. T. The appeal process. The FRA solicited comments whether the added provisions to propose the statute 242-503B, provided if the petitioner is requesting review of the railroad decision which is based on failure to comply with any drug or alcohol-related rules or return to the service of agreement, the petitioner shall supplement his or her petition with the relevant written documents, including information under the Title 49 CFR 40.329. The laboratory's medical review officers or other service agents are required to release the employees. The petitioner should be provided a written explanation if the petitioner's written documents that should be reasonably available to the petitioner are not supplied. See the C75 FR 69166 or 6 and 69185 November 10th 2010 AAR Associated Support with provision of the Brotherhood of Locomotive Engineering Training Men in the United Transportation Union commented on the Federal Railroad Administration should be a requirement for the railroad to notify the conductors in written of the right to the acquired litigation package of the laboratories. The MRO and the other services agents discussed in the conductor of the record of the revocation hearings conducted in compliance with the statute 242-407B4 for charging the violation of 242-403E. Well, the Brotherhood of Locomotive Engine Training Union and the United Transportation Union suggested at a minimum the notification should contain exact language contained in Title 49 CFR 40.329. Because of the OCR may not need information listed on Title 49 so CFR 4329 in all cases because there may be some costs associated with obtaining information. The FRA has adopted a modified version for the proposal of this final rule, which clarifies that the petitioner will be responsible for obtaining information on the listed Title 49 CFR 403029. If requested by the OCR, this will not mandate the petitioner to submit the information listed in Title 49 CFR 40.329 to the OCRB in all cases involving violation of the statute 242-43A12. The FRA expects in those cases the OCRB does not information listed in the Title 49 CFR 4329 or the OCRB will explain the petitioner with the information is looking for to obtain the petitioner, however the petitioner can get it, and consequently, FRA declines to adopt the Brotherhood of Locomotive Engineering Training and the United Transportation Union additional requirement. The Brotherhood Locomotive Engineering Training and the United Transportation Union submitted numerous comments regarding changes that wanted to see the made of the appeals of the process contained in the proposed in section 242, 501, 503, 505, 507, 509, and 511. According to the Brotherhood Locomotive Engineering Training Trainmen, the United Transportation Union, the change will create a more expeditious process, resolve disputes that may arise with the conductor certification rules. The suggested change will eliminate the opportunity for the parties to appeal the FRA decision to the administrator, incorporating the administrative hearing officer level through the appeal in the OCRB process, requiring the OCRB to grant the decision in procedural error by the railroad is showed adding an attorney as a member of the OCRB, making the OCRB a decision final agency action. The FRA declines to adopt the Brotherhood of Locomotive Engineering Trainmen and the United Transportation Union proposed revisions to the appeal process. The proposed processes will be thoroughly discussed in working group meetings, and the Brotherhood of Locomotive Engineering Training and the United Transportation Union suggests were rejected at those meetings. As explained to the working group due to the process requirements issued concerning trails of the de novo necessity of the FRA retained at the OCRB and the AHO distinct levels of review. Contrary to the Brotherhood of Locomotive Engineering Training Union, and the United Transportation Union claims, the FRA believes that the Brotherhood of Locomotive Engineering Trainmen in United train union suggests the revisions actually increase the amount of time and cost it to resolve. The average case of appeal to the FRA under the Brotherhood of Locomotive Engineering Training and the United Transportation Union. The FRA expects significantly increase the number of the cases issues handled by the AHO, the federal courts, and for example, the Brotherhood of Locomotive Engine Training Trainmen and United Transportation Union proposed that it appears the decision of the OCRB to deny the petition and untimely would appeal to the federal court that the decision would constitute final agency. The important to appeal the decision of the administrator as provided in the notice provision rulemaking would be eliminated. As a result, the case to make much longer and would involve increased costs of all parties. More of the Brotherhood of Locomotive Engineering and Trainmen United Transportation Union proposal advocates extend for the time of the filing of the petition of the review of the Federal Railroad Administration for 4 months as provided by the notice of the provision rulemaking to 6 months. The extension would only add time required for the cases resolved by the FRA following the railroad's decision to deny or revoke certification. Although the FRA is not adapting the Brotherhood of Locomotive Engineering Trainmen and the United Transportation Union proposals, the FRA is taking steps to make the appeals process more efficient. One of the most past 2 years, the average length of time of the AAHO to render the decision on locomotive engineering case under the Part 240 has dropped by 6 months due to the part of the AHO is now no longer allowing parties to hold a case in abeyance. The FRA expects the AHO would not conduct a case in abeyance, thereby eliminating one of the main obstacles to achieving faster processing times. In addition, the FRA has revised the requirements proposed by the notice of the provision rulemaking to require petitions to submit the docket clear of the dot rather than the FRA docket clerk. With changes to the process, submitting petitions to the OCRB will parallel the process of requesting administrative hearings under Part 240 at Statute 242-507. The FRA believes the changes will make the process more efficient for the DOT, Department of Transportation dockets, and is better equipped to process and scan those types of filings. Use civil penalty and schedule. In the notice of the provision rulemaking, the FRA noted that the Appendix A of the final rule would continue the penalty schedule similar to the FRA has issued all of the existing rules, such as the schedule statements of this policy, therefore no subject to notice of the comment of the requirements. Nevertheless, interested parties were welcome to submit their views on the penalties may be appropriate. The Brotherhood of Locomotive Engineering Training and the United Training Union Transportation Union submitted comments which were considered in developing the penalty schedule in Appendix A in this final rule. Procedure for submission of programs. The FRA solicited comments whether it required of each of the railroads to provide its program submission. Required under Statute 242-101 and 242-103 electronically. Since the FRA did not receive any comments on the issue because the FRA believes that such an opinion will allow Federal Railroad Administration to review submission most efficiently, eliminate the need to store the hard copies of numerous submissions, the FRA has included an option in Appendix B of this final rule. W. Vision color test. In the notice of provision rulemaking, the FRA solicited comments regarding the vision color test should be included in the Appendix D of this rule. Since the FRA did not receive any of the comments on this issue because any of the changes to the list of the vision colors and tests will appear to fall in the purview of the Medical Standards Working Group, and the proposed vision color test contained in the notice of provision rulemaking will be adopted in this final rule. 5. Section by section analysis. Alright, section by section analysis. Subpart A. The Subpart A rules that contains the general provision of the rule, including the formal statement of the rule purpose and scope. The subpart also provides the rule which does not contain the railroad's ability to prescribe additional, more stringent requirements for the conductor that are not inconsistent with this rule. Section 242, purpose of the scope. The section derived from the Title 49 CFR 240.1 prescribes the minimum standards of the eligible training, testing, certification, monitoring of the person who serves as conductor. This section indicates the purpose of the rule is to ensure only those persons who meet the minimum federal safety standards serve as conductors to reduce the rate of the number of accidents incidents to improve railroad safety. Despite the fact that the person may have a jobs classification title other than that of the conductor certification requirements of the rule apply to the person of he or she defines on the conductor. The definition of conductor and explanation who is covered in the definition is discussed in detail in section analysis 242.7 below. Section 242.3, Application Responsibility and Compliance. The section derived from the Title 49 CFR 240.3. The section provides the rule applies to the railroad with the three exclusions. The two exclusions address several types of operations that occurs in the tracks that are not on general railroad system. The exclusion encompasses operation commonly described as tourist, scenic, and excursion services to extend that they occur on the tracks that are not on general railroad system. The exclusion also addresses operation that occurs with the confinedness of industrial installations, commonly referred to as plant railroads, type by operations such as steam mills that did not go beyond the plant boundaries, that don't involve switching rails or for the entire infra entities other than themselves. In other regulations, the FRA did not define the plant because it assumed the FRA jurisdictional policy statement provided sufficient clarification. In the 2010, FRA became aware of the certain operations called themselves plant railroads, but were exceedingly limitations required to maintain plant railroad status according to the FRA policy statement. The FRA would like to avoid any confusion with means to be in plant railroad, defining the term of the final rule, thereby serving interested persons the effort and necessary to cross-reference the FRA jurisdiction policy. Further discussion is whether it is meant the term plant railroad is offered by section analysis for section 242.7. The FRA also excludes tourist, scenic, historic excursion operations that are not part of the general railroad system of transportation as defined in Statute 242.7. For the compliance of this rule, in Section 242.7, the FRA defines the operation of the tourist, scenic, historic excursion operation conducted only on the track used exclusively for that purpose, i.e., there is no freight intercity passenger commuter passenger railroad on the track. Exceeding these type of operations from the rule is consistent with the Federal Railroad and jurisdictional policy. This also excludes these operations from all but a limited number of the federal safety laws and regulation orders. The third exclusion covers the rapid operation of the urban area that are not connected to the general system. If this should not be, however, some rapid transit type operation given the link to the general system, whether the FRA jurisdiction FRA specifically intends to the rule that apply with the rapidly transit the type of the operation. This rule is not intended to have any effect on the FRA jurisdiction. Since this rule is intended to apply to some of the railroads covered on Part 240, one should refer to the preamble of the discussion in Title 49 CFR 240.3 or CF 64 FR 60966, 60974, November 8, 1999, or 63 FR 5062, 5636, and 5637. September 22nd, 1998, or 56 FR 2822. 228 or 240 for a more detailed analysis applicable to this rule. Section 242, the effect on construction. This section addresses several legal issues. Paragraphs address the relationship ruling pre-existing legal relationship. Paragraph B states that the FRA does not intend the authority of the railroad to initiate disciplinary sanctions against its employees by issuance of this rule. Paragraph C is the section addressed for the issue of the flowback. The term of the flowback has been used in the industry to describe the situation when an employee leaves his or her current position to return to a previously held position or craft. Example of the flow occurs when the person who holds a position conductor subsequently qualifies as a position of locomotive at the same later point in the time personally finds necessary or preferable to revert back to a conductor position. This reason is reverting the previous craft may be derived from the personal choice or less or voluntary nature of, e.g., downsizing. Many collective bargaining agreements address with the issue flowback. As the general matter, the FRA does not intend to prohibit the right of flowback to take a position whether the flowback is desirable. However, the paragraph C of the section must read to the conjunction of the statute 242-213, which limits the flowback in certain situations, as described in section analysis section below. A person who holds a conductor or locomotive engineering certificate who has had his or her locomotive engineering certificate revoked could not work as a conductor during the period of the revocation. In addition, with a person whose conductor or locomotive engineering certificate who has had his or her conductor certification revoked for violations could not work as a locomotive engineering during the revocation period of revocation. Paragraph D, the section addresses employee rights. The intent of the rule explicitly preserves any of the remedial already available to the person, not to create any new entitlements. The FRA expects that employees would benefit in this paragraph by referring to the should a railroad or the use of the regulation to inappropriate explanation of the ignoring the employee's rights or remedies. The railroad must consider whether any procedural rights or remedies available to employee will be consistent with the part. Section 242.7, the definitions. The section contains definitions of the FRA employees in the rule. Most of the definitions are essentially verbatim from Title 49 CFR Part 20 have been thoroughly analyzed in the rulemaking. Parties seeking the detailed analysis for the definition should refer to the Part 240 rulemaking documents. See 54 FR 5890, December 11, 1989. 56, a couple FRA parts. Some of the definition of the rules, however, they have not found in Part 240 have been substantially modified for the part of 240. The definition are analyzed below. As mentioned, potential rulemaking for medical standards of Title 49, Part 219, control of alcohol drug use may impact the definitions of Part 20 and 242. For example, definitions of relating to medical standards, the e.g. medical examiner, the drug alcohol control substance abuse disorder in Parts 240 and 242 may be superseded by definitions provided in the rulemaking. However, until those rulemakings are promulgated, in definitions 240 and 242 will control the conductor. Although the RSI requires the FRA to establish a program certification conductor, the Act does not define the term of the conductor. Without guidance from the Acts of the FRA proposed, the RSAC recommends the definition of a conductor be based on generally understanding responsibility of that proposition, similar to 24's approach, Part 240's approach defining locomotive engineering. The rule defines that the conductor crew member in charge of the train or the yard crew as defined as Part 218 of the chapter. Part 218 defines train or yard crew. One or more railroad employees assigned to the controlling locomotive under the charge of control one of the crew member to perform the service covered in Section 2 of the Hour Service Act involved with the train yard movement of the railroad rolling equipment that are working with and is an operating crew. Reporting working together at the unit remains in close contact if more than one employee may subject to the railroad operating rules, programs, operational testing, inspection required in section or statute 217.9 and 217.11 of this chapter. As of the use of singular term for the crew member suggests, the FRA definition mandates only the one person that can be in charge of the train yard crew, and the person that seems to the conductor for the purpose of this regulation. More in some circumstances, locomotive engineer includes the remote control operator will be required to certify the locomotive engineering under Title 49 CFR Part 240 as a conductor under this rule. See Title 49 Code Federal Regulations 242.13. All of the train and yard crew, AG, assistant conductors, brakemen, holsters, trainmen, switchmen, utility person, flagmen, yard helpers, who might have different job titles, have become similar duties and are not in charge of the train or the yard crew, do not fall in the definition of a conductor for the purpose of this title. Drug and alcohol counselor. For the term of the drug and alcohol counselor means the person who meets the credential qualification requirements of a substance abuse professional, as provided in Title 49 CFR Part 40. Ineligible and ineligibility. The ineligibility, which is not used in Part 240, means that the person is legally disqualified from serving as a certified conductor. This term broadly defines a number of circumstances in which a person may not serve as a certified conductor, revoking the certification pursuant to Statute 242.407, denial of the certification pursuant to Statute 242.401. The two examples of this person will be ineligible to the service conductor. The period ineligibility may and when conditions are met. For example, when a person meets the conditions of service conductor following an alcohol drug violation pursuant to Statute 242.115. The job aid. The term job aid, which is not used in Part 240, is defined in information regarding the mainline track main track physical characteristics supplements of the operation instruction of the territory over the locomotive training movement will occur with the terms main track and physical characteristics described below. The term job aid is broadly defined as the rule job aid consists of the information contained by the variety of sources, including but not limited to training the territory pursuant to Statute 242.11.19, maps, charts, visual aids of the territory, other persons contact who qualified on the territory or who can be described as physical characteristics of the territory. While each of the railroad will have the flexibility on how to convey its job and to a conductor, the job aid will, with a minimum, have to cover the characteristics of the territory over the locomotive and train movement will occur, including permanent closed clearances, low permit derail switches, assigned radio frequencies, and use special instructions required for the movement if any of the railroad identified unique operation conditions. The pursuant to Statute 242.121(c)(4)(b), each railroad will require to test the conductors and conductor candidates of one of the use of any job aid for the railroad car could provide a conductor. Section 242.301 describes the condition under which the railroad should provide a conductor with a job aid. Mainline tracking. The term mainline tracking is defined as a track upon the operation train is governed with one or more of the following methods of operation: timetable, mandatory, directive, signal, indication. Positive train control is defined in Title 49 CFR Part 236. Any of the form of the absolute manual block system. The definitions mirror the definition of the main track in the Title 49 CFR Part 240, which also includes a reference to the positive train control. Medical examiner. The term medical examiner is defined by a person licensed or doctor of medicine and the doctor of osteopathy. A medical examiner may be qualified full-time salaried employee railroad qualified practitioner who contracts with the railroad on a fee for the service or other basis. The qualified practitioner is designated by the railroad to perform functions in the connection with the medical evaluation of employees. Under this rule, the medical examiner owes the duty to make an honest, full, informed evaluation of the condition of any employee. The only difference between the definition of a medical examiner in this rule and the definition of Title 49 CFR Part 240 is the part of under the 240 where the medical examiner owes a duty to the railroad. In this rule, however, the words to the railroad has been deleted, but the change would be addressed to the concern with the working group members that medical examiners should not owe a duty to just the railroad, rather than show a duty to both the railroad and being the employee being evaluated. On the job. The term on the job, in which is not defined in Part 240, means that the job training that occurs on the workplace as the employee learns to job while doing the job. Passenger conductors. The term passenger conductor is defined by the conductor who has also received emergency preparedness training under Title 49, Part 239. Interested parties should note that nothing in the rule requires a conductor for the private or non-revenue movements. Business car specials to have an ERP or emergency preparedness training plan. This position is consistent with the Title 49 CFR 239.3b. Physical characteristics. The term physical characteristic, which is not defined in Part 240, means that the actual track profile of the physical location for the points of specific yards en route after the movement of the locomotive or train. Physical characteristics involved with the main track physical characteristics. The main track is analyzed above, and the other main track physical characteristics. For example, physical characteristics can include permanent closed clearance, location of permanent derail switches, and grades. The plant railroad. FRA includes the definition of plant railroad in the final rule aid. Understanding the application for the pursuant of the Statute 242.3. The definition coincides with the FRA long-standing explanation of how the agency will not exercise its jurisdiction over a plant railroad that does not operate on the general system, does not move cars on the other entities. See the Title 49 CFR 209 Appendix A. Qualified. The term qualified is defined as a person who has successfully completed all the instruction, training, and examination programs required by the employer. The applicable parts of the chapter, therefore, could reasonably be expected to be proficiently on all safety-related tasks of the person assigned to perform. The definition of the qualified of the rule differs from the definition of Part 240. In the Part 240 definition focuses on personal knowledge, whereas the definition of the rule the focus not only on the knowledge but also whether the person could reasonably expected to be proficient at performing all assigned tasks. The up-to-date definition of the qualified is an attempt to ensure that the railroad instruction training program not only provided knowledge on how to perform the task but also of the ability to proficiently perform the task. Qualified instructor. The term qualified instructor is derived from the definition instructor engineer. Then Part 240 means the person who has demonstrated pursuant to the railroad written program an adequate knowledge of the subject under instruction, where applicable has necessary operating experience to effective instruction in the field. A qualified instructor is required to have the following qualifications. It is a certified conductor under this part, has been selected as a designated railroad officer in concurrence with the designated employee representative where and present. In the absence of concurrence provided in paragraph 2, this definition has a minimum of 12 months of service of the trained service employee. If a railroad does not designate an employee representative, then any person employed by the railroad need not to comply with the items 2 and 3. The definition is to be called the qualified instructor. Item 2 and 3, while not found in the part of the 240 definition, instructor engineer are included here to address the concerns of the working group members that employees through their representatives should have input on the selection of the instructors who might be reviewed in the experience of the IE person in less than 12 months services and working as a training service employee. Railroad rolling stock. The term railroad rolling stock means the track of equipment that is either railroad freight car as defined in statute 215.5 of the chapter or on passenger car as defined in 238.5 of this chapter. This term matches the definition of railroad rolling stock of the notice of provision rule making. In Part 240, except for the word railroad, has been added to the term freight car to the mirror the defined railroad freight car in statute 215.5 of this chapter. Remote control operator. The term remote control operator, RCO, means the certified locomotive engineer as defined in statute 247 of this chapter, certified by the railroad to operate the remote control locomotive pursuant to statute 240.107 of this chapter. Although this term is not defined in Part 240, the FRA intends to have for the term to have the same meaning in this rule as due to its parts. 240 FRA defines the term in this rule to avoid any confusion as those of the rule as referring to when it is in reference to the remote control operator. Substance abuse disorder. The term substance abuse disorder refers to a psychological, physical dependency on alcohol or a drug, other than an identifiable, treatable mental or physical disorder involving abuse of alcohol or drugs as a primary manifestation. The FRA intends for a definition to include drug alcohol users who engage in abuse patterns with the result of ongoing safety risk and violations of the FRA drug alcohol prohibitions. These type of substance abuse may demonstrate compulsive, excessive, self-damaging use of the drug alcohol, such as any manifest as a DUI or DWI, a violation of FRA drug alcohol prohibition, substitution-related accidents, incident substance-related behavior, which has resulted in significant safety breach while under the influence impaired, including the having hangover effect of these patterns of the abuse, may result in dependence, physical injury, and psychological harm, but are not necessarily defined as diagnosed or offered by a healthcare professional. A substance abuse disorder is active when the meaning of the rule is the person is currently using alcohol or other drugs except for the other under the medical supervision consistent with the restrictions described in Statute 219.103 of this Chapter 2 has failed to successfully complete the primary treatment of successful participation in aftercare is as directed in substance abuse professional or drug alcohol counselor. The definition of substance abuse disorder in this rule is the same definition in Part 240 except for the two respects. The first part of 240 definition refers to the EAP and the counselor rather than the ASAP or the DAC. The SAP and DAC often have more stringent credential knowledge, training, continuing education requirements relating to the substance abuse of the EAPs, SAPs, and DACs may be qualified as direct a person's treatment and aftercare. Second part 240 uses the phrase using alcohol or other drugs when describing activity substance abuse disorder. The rule revision phrase to read is currently using alcohol or other drugs. The FRA made the revision clarify its intent of the person within an inactive substance abuse disorder could be using alcohol or other drugs. The definition for substance abuse disorder is similar to those to the language employed with the governing disposition of employees referred to the Employee Assistant Program under the Co-worker Report Bypass provisions of the Alcohol Drug Regulations. It is describing conditions, substance abuse, chemical dependency, which requires intervention and or as treated by an appropriate professional. The FRA's intent is that the person which is uncontrolled use of the alcohol drugs is not suitable candidate for legible sensitive duties entrusted to a conductor. The definition explains that the disorder is considered active within the meaning of the other rule that is not if the person is not currently abstaining from use of alcohol and drugs, except for the under medical supervision consistent with the FRA's alcohol drug regulations, has failed to successfully participate in aftercare and is directed to the SAP or DAC has been failed to successfully complete the assigned course of the education counseling treating as required. The FRA is aware of the individual abuse of alcohol and drug with the consequent ill effects of the health of the potential implications for the fitness without fitting the common definitions. The chemical dependency, the critical point of here with the respects of safety conductors not to be in the grip of uncontrolled abuse patterns that, if and addressed through the treatment and the permanent absence, could be put in behind. Substance abuse professional. SAP. The substance abuse professional means it's a person who meets the qualifications of the substance abuse professional as provided in Title 49 CFR Part 40 to avoid interfering with the established rules and definition of the Department of Transportation Drug Alcohol Regulations. The reference to the drug duty found in the new odor prevention rule making definitions of the substance abuse professional has been deleted. The territorial qualifications. The term territory qualification means the possessing necessary knowledge concerning railroad operating rules, timetables, special instructions, including familiarity with the applicable main track and other main track physical characteristics of the territory over the locomotive and train movement will occur, although not as defined in Part 240. The term is derived in Part 240's requirements that, with certain exceptions, the locomotive engineer may not operate the locomotive over the territories unless the engineer is qualified on the physical characteristics of the territory. See Title 49 CFR 242. 31. Pursuant to 242.301 of this rule, a person's certain expectations could not serve as a conductor unless the person was certified and possessed the necessary territorial qualification for the applicable territory. Scenic historic exertion operations that are not general part railroad system or transportation. The final rule offers the definition of the phrase tour, scenic, historic, or exertion or operations that are not part of the general railroad system of the transportation in order to explain the planning of the meaning of the phrase that is used in Section C, Statute 242.3. The phrase means of the tour, scenic, historic, exertion, operation conducted only on the track used exclusively for that purpose. There's no freight, intercity passenger, commuter passenger railroad operating on the track. If there's any freight, intercity passenger, commuter passenger railroad operation on the track would be considered to be part of the general system. See Title 49 CFR Part 209A Appendix A in the analysis applicable section, the explanation for why the FRA is proposing not to exercise jurisdiction over these types of railroad operations. Statute Section 242.9 waivers. This section attracts regulatory language in Title 49 CFR 240.9 provides the requirements for the person seeking a waiver of any section of this rule. Section 242.11 penalties and consequence for noncompliance. This section tracks for the regulatory language in Title 49 CFR 240.11 provides a minimum maximum civil penalty amount determined in accordance with the Federal Civil Penalties and Inflation Adjustment Act of 1990, Public Law 101-410, and Statute 890, 28 U.S. Standard Code 22461, note as amended by the Debt Collection Improvement Act of 1996, the Public Law 104 and 134, and April 26, 1996 of the RSIA. Section 242.13 Information Collection Requirements. The section list of the section of the rule which contains information collection requirements. Subpart B, the program eligibility requirements. The subpart contains the basic elements of the conductor certification program required by this rule based on the RSIA's requirement of the certification of conductors. The FRA experience with the certification of locomotive engineering for the rule-making adoption of the certificate system of the FRA sets eligibility criteria for but leaves it to railroads to evaluate the candidates for those standards rather than the traditional licensing system, i.e. the government agency sets eligibility criteria and evaluates candidates. As within Part 240, this rule affords the railroads considerable discretion of the daily administration of their certification program. Section 242.101, certification program required. The section requires railroad to have a written program composed of 6 elements in which comports the specific provisions relating to the element. The effective date of the final ruling of January 1st, 2012. The rest of the dates provided in the rule EGA dates of each railroad must be designated to its eligible conductors in Statute 242.105 are based on the effective date. Section 242.103, approval of the design of the individual railroad program by the FRA. The section requires each of the railroads to submit a certification program to the FRA for the approval of accordance with the schedule provided within this final rule. The schedule for the submission in the paragraph A requires the Class 1 railroad, Amtrak, the commuter railroads, the Class 2 railroads to submit their programs at an earlier date than the Class 3 railroads other than not classified elsewhere. The format, contents of the submission are discussed in length in Appendix B to this rule. Unlike Part 240, this rule requires that the railroads serve a copy of their submissions and resubmission material modifications on the president of each labor organization that represents the railroad certified conductor. Within 45 days of the filing of any of these submissions with the FRA, any designated representative of certificate conductor submits comments on the railroad submission. The FRA, although the FRA does not commentary, will determine whether a railroad submission is approved. The FRA expects that the comments will be useful in determining whether the railroad program conforms to the criteria set forth in this rule. This section also requires that each of the railroad is to indicate how it intends to employ the future conductors if the railroad accepts the responsibility for training a previously uncertified person to become a conductor. The railroad must explain the training regimen for such a trainee, including provisions for relying on outside training organization to provide actual training. The rule provides 30 days for the FRA review approval for the railroad program. The FRA is proceeding in this manner because most of the railroads have existing programs, including locomotive engineering certification programs, intended to accomplish a similar goal that can be easily modified. The quality of such a program is generally good for the program. Problems that may be encountered would not likely to be involved. Basic design flaws generally would not surface until the FRA had time to observe the actual administration of the program. In screening all submissions, the FRA should be able to quickly detect any substantial deficiencies. Given the quality of the existing programs, the FRA seeks little value of delaying implementation of the programs for time-consuming agency review. The FRA may, of course, disapprove of any program during the review cycle or a later date. The FRA will explain any deficiencies in writing. The section will require a timely railroad response to the FRA disapproval action of railroad will have no more than 30 days to revise and resubmit the program. Paragraph G2 of this section, which has been modified for the notice of provision of rule making, provided with the administrator informs the railroad deficiency in its program more than 30 days of the initial filing date. The original program may remain in effect until 30 days after the approval of a revised program is received, so long as the railroad complied with the requirements for resubmitting the program that was deemed deficient. Section 242.105, Scheduling of Implementation. The section contains a timetable implementation of this rule. Paragraphs A and B of this section require the railroads and written designation certified conductors, all personnel authorized railroads to perform the duties of the conductor as an effective date of the final rule. Authorized between the effective date of the final rule and the date specified in paragraph D and 5 of the section to issue certificates to each person it designates. The mandatory designation requirement of the section includes to address the concerns of some working group. The railroad should not be given discretional potential engaged in desperate treatment of its employees. I.e. designated and provided certificate to some people who are authorized to perform duties of the conductor as an effective date of the final ruling, but not others. Paragraph C. This section requires each of the railroad to make formal determinations concerning their employees. It is designated as conductors within 36 months of the date from compliance by its class of railroad. Pursuant to this paragraph, a designated for the compliance Pursuant to this paragraph, a designated conductor may serve as a conductor for up to 36 months from the date of the compliance of the railroad. I.e., the date is specified in the paragraph D and E of this section. At the end of the 36 months, however, the designated conductor can no longer serve as a conductor unless he or she successfully completes the test evaluation provided in subpart B of this rule. The full certification process, the railroad should know that they may not test and evaluate a designated conductor or conductor candidate under subpart B of this rule. Until they have the certification program approved by the FRA pursuant to Statute 242-103. In order to test and evaluate the designated conductor by the end of 36 months, a large railroad will likely have to begin with the process well in advance of the end of 36 months. For example, paragraph C, which is derived in part 240, designated provisions would permit a railroad to test and evaluate 1/3 of its designated conductors with 12 months of the railroad date of the compliance, and another 1/3 of 24 months of the day of the compliance, and the final 1/3 within 36 months of its date of compliance. Some of the working group members raised concern as designated conductor who would be eligible to retire within 36 months of the date of the compliance by their class of the railroad. Specifically, some of the members did not believe that it was sufficient use of resources to perform a full certification process of a designated conductor who is going to retire before the end of the 36 months designated period. To address the concern, paragraph C1 provides a designated conductor who is eligible to receive a retirement pension in accordance with the term of the applicable agreement and or the terms of the Railroad Retirement Act within 36 months prior to the date would be required to be tested and evaluated under subpart B of this rule may request and written under the railroad not perform the full certification process on the designated conductor until 36 months from the date of required testing and evaluation. Paragraph C3 provides that upon the receipt of the written request, the railroad may wait to perform a full certification process on the person making the request until the end of 36 months is designated period. Thus, paragraph C1 and C2 allows designated conductors to serve as conductors for a full 36 months designated period and then retire before they be subject to full certification process. While it is in the railroad's interest not to perform a full certification process of a person who is going to retire once designated period expires, thus it is interest to grant as many of the requests as possible. It may not be feasible to accommodate every request that is made. Even if, for example, a significant number is designated as conductor on a railroad properly, request the railroad wait and recertify them at the end of the designated period, then do not, in fact, retire the expiration of 36-month designated period. The railroad might not be able to certify everyone in time would risk a violation of this final rule. In the recognition of the risk of the need to give the railroad some flexibility to comply with this rule is paragraph C2. Allows to provide that the railroad grants any request must grant the request of the eligible person to every extent as possible. In addition to the paragraph C3 provided that the designated conductor who is also subject to recertification under Part 240 may not make a request under paragraph C1 or of this section. The provision recognizes that the railroads would likely to have a concurrent certification process with certifying a person who will be certified locomotive engineer or conductor. Thus, it would be not be appropriate in the instance of a designated conductor who is already subject to the recertification under 240 to make a request or delay a full conductor certification process. Paragraphs D and E and F provided that they are after specified dates. No railroad recertifies a person as a conductor. No person may serve as a conductor unless that person has been tested, evaluated in accordance with the procedures provided in subpart B of this rule. Issued in certificate interested parties should note that the month they provided in the paragraph E has been changed to September 2012. It is provided in the notice of provision rule making on October 2012 so that the class 3 railroads would have approximately the same amount of time in 2 months as the class 1 and 2 or commuter railroads between the submission of the program to the FRA and the time of having to be and approve the program in place. Section 242-107, Types of Service. This section creates the two types of conductor service, conductor and passenger conductor. It indicates the definition section of the rule of the passenger conductor is a conductor who has received emergency prepared training under the Title 49 CFR Part 239. Paragraph C of this section derived from the Title 49 CFR 240-107 prohibits the railroad reclassification certification of any type of certified conductor to a different type of conductor certification during the period within which the certification is otherwise valid except after the conductor completes the Title 49 Parts 239 emergency training is certified as a passenger conductor. For example, this rule prohibits the railroad from requiring a passenger conductor to exchange his or her passenger conductor certificate for the conductor certificate during the period with which the passenger conductor certificate is otherwise valid. While this rule prohibits the practice of reclassification, it does not prevent the railroad from pursuing other measures to ensure the safe and performance conductor service. For example, the rule does not prevent a railroad from replacing restriction on certification pursuant to paragraph D of this section. It should not be noted, however, that while paragraph D permits the railroad to place a restriction on the certificate, any restriction would be applied reviewed in accordance with the internal railroad rules, procedure, and process. Part 242 does not give an issuance review of the restriction as would be the matter handled under the railroad internal discipline or collective bargaining agreement. See statute 242.5 A, B, and D. Section 242.109 determines required certificate recertification. The section listed in the determinants required the evaluation of the candidate's eligibility to be certified or recertified. The reference to statute 242.403 in the paragraph A of the section to ensure that the railroad determined that the candidate is currently ineligible to so hold the certificate due to this revocation addressed in subpart E of this rule. Paragraph B1 has been modified to clear intent of the section. The FRA deleted with reference to the railroad employment record of the railroad safety conduct, since the paragraph also implies non-railroad conduct such as a motor vehicle operation. Interested parties should note that the dispute of the provisions of statute 242.101 and 242.115 require reviewing of the safety conducting information from the following preceding 5 years. Paragraph B1 of this section does not permit the railroad to consider information concerning safety conduct that occurred prior to the effective date of this final rule, although all that the paragraph may result in evaluation of less than 5 years' worth of information of some conductors includes but part of the 242. The reason of the provision was also included in Part 240 rulemaking. 256R 228, 228, and 228 242 Rule 1990, June 1991. Since the motor vehicle data is required to be sent to the railroad rather than this candidate, the paragraph D of this section requires the railroad to provide a candidate certification, recertification, and an opportunity to review the comment of any record which contains adverse information. This review will avoid potentially or for our reliance for records of where somehow erroneously associated with the candidate. Paragraph G of this section provides flexibility to the railroad conductor candidates and obtain the information required in statute 242.11 and 242.113. For example, paragraph G would permit a conductor and a railroad to enter into the agreement allowing the railroad to request the conductor's service record from a previous employing railroad pursuant to statute 242.113. Section 242.11 Prior safety conduct as a motor vehicle operator. The section derived from the Title 49, 241.111, and 240.115 provides that the requirements procedure for the railroad must follow the evaluation of a conductor's candidates prior to the conduct of the motor vehicle operator. Although some of the working group has suggested that the information regarding the prior safety of a motor vehicle operator was unnecessary in determining whether a person should be certified as a conductor, the FRA believes that the prior safety conduct of a motor vehicle operator is one indicator of the person's drug or alcoholic use. Therefore, any importance per piece of information for a railroad to consider. Pursuant to this section, each person seeking certification or recertification conductor must require that in written that the chief of each of the driven license agency that issued him or her driver's license was preceding 5 years provided a copy of person driving record to the railroad. Unlike Part 240, this rule would not require individuals to also request motor vehicle operator information from the National Driver Registry. It is FRA understood that based on the National Driver Registry Statute, Regulation C, Title 49, U.S. Standard Code 303, and 23 CFR 1327, railroads are prohibited from running the National Driver Registry with checks and requesting National Driver Registry information from individuals seeking employment as a certified conductor. During work group meetings, members in work group raised concerns that the conductor candidates who had properly requested motor vehicle operation information was unable to be recertified as a conductor because of the delay mixed up with the driver license agency in sending the required information to the railroad. To address the concerns, paragraph C and D of this section required the railroad to recertify persons in 60 days of its person requested the required information 60 days prior to the date of the decision. Recertify, otherwise means eligibility requirements provided with the 242.109 109 of this rule. If the railroad recertifies the person for 60 days pursuant to paragraphs C and D, but is unable to obtain the evaluated required information during those 60 days, the person is ineligible to perform as conductor until the information can be evaluated. However, the person is simply unable to obtain the required information that the person recertifying the railroad could petition the waiver from the FRAC Title 49, Part 211. During this dependency, the waiver request the railroad would have to certify or recertify a person if the person otherwise meeting the eligible requirements of Statute 242-109 of this final ruling. Paragraph 1 of this section requires certified conductors or persons seeking the initial certification to notify and employ the railroad motor vehicle incident described in paragraph N of this section within 48 hours of the conviction of completed state. Action that stands or revocation, suspended, denying of a motor vehicle license. The paragraph also provides the purpose of the conductor certification. A railroad cannot have more than a restricted company rule requiring an employee to report a conviction or completed state action to cancel, revoke, deny, or motor vehicle license in less than 48 hours. The reason behind the paragraph involves the several intertwining objectives. As a matter of fairness, the railroad should not revoke, deny, otherwise make a person's ineligible certification until the person has received due process from the state agency taking action against the motor vehicle license. Otherwise, action pursuant to this part may be deemed premature, since the American criminal justice system is based on the concept that a person may be being innocent until proven guilty. Further, by not requiring reporting until 48 hours after the completed state of action, the rule will be practical effect, ensuring that the required referral to the drug alcohol counselor under the paragraph O of this section would not occur prematurely. Interested parties should note that, however, the paragraph L does not provide an eligible person from choosing to voluntarily self-refer pursuant to statute 242.11.5 D3, nor does it prevent the railroad from referring to the person from an evaluation under the initial railroad practice or initial railroad policy, and other information exists for the identifying person as possible having a substance abuse disorder. For the restriction applies that the action taken against the person's certificate does not affect on the person's right to be employed by the railroad. As mentioned above, the paragraph O of this section provides in such a motor vehicle incident that is described in paragraph N is identified as the rule, or the railroad is required to provide the data of the drug alcohol counselor along with any information concerning with the person's road service record. Furthermore, the person would have and refer to the evaluation to determine the person had been active substance abuse disorder. If the person has such a disorder, the person could not be currently certified, Alternatively, even if the person is evaluated not currently affected by the active substance abuse disorder, the railroad would be required and recommended by the drug alcohol counselor to condition certification participation needed aftercare follow-up, the testing alcohol drugs review. Both the intent of the provision is to use the motor vehicle record to expose the conductor or the conductor candidates who may have active substance abuse disorders, make sure that they are referred to the evaluation or necessary for the treatment, for allowing them to have proper safety-sensitive services. Interested parties should note that any testing performed as the result of drug alcohol counsel recommended under the paragraph will be done under the company authority, not federal, although testing will be still required to comply with the technical standards of Part 219, Subpart H, and Part 2, Part 40. Paragraph OH has been added to the final rule, clarifying the failure to cooperate with the drug alcohol counseling evaluation will result in the person being ineligible to perform as a conductor until such a time as the person cooperates in the evaluation. 242.11.13 proper safety conducts as an employee of the different railroad. The section of the rule which is derived in Title 49 CFR 240.11.13 and 242.05 provides a process of requesting information regardless of the candidate's prior safety conduct, if any, of the point as a different railroad. Section 242.115 Substance Abuse Disorder, Alcohol, Drug Abuse, Drug Rule Compliance. The section derived from Title 49 CFR 241.19, 242.05 addressed the two separate dimensions of alcohol drug problem in relation to the conductor's active substance abuse disorder, specific alcohol drug regulatory violations. This is the section 242.111 111, and address to certain situations, inquiry must be made into the possibility that the individual has an active substance use disorder. If the individual is to obtain or retain a certificate, the fact that specific instances cited in this section would not exclude the general duty of the railroad to take responsible proportional act of the appropriate class. Cases decline job performance, extreme mood swings, irregular attendance, other indicators may, to the extent immediately applicable, indicate the need of evaluation under internal railroad policies. The FRA acknowledges that there could be a legitimate reason why someone may exhibit some of the all of the conditions identified. However, these conditions extend not immediately expectable, may also be indicated that a need for evaluation. A purpose of identifying the condition is not required, as it does not require the railroads to order an evaluation at any time it listed in condition exhibited. Rather than the FRA simply provided the guidelines on the condition that they might be given the context or call for the evaluation under internal railroad policies. Moreover, the FRA remains vigilant of harassment and intimidation and will take an appropriate action when such conduct is discovered. Paragraph A reaches each railroad to address both dimensions of the issuance of the program. The paragraph B and C requires each of the railroads to determine that the person initially certifying the conductor recertifying meets the eligibility requirements of this section. Additionally, each railroad is required to retain the documents used to make the determination. Paragraph D provides that the person is with an active substance abuse disorder currently certified as a conductor. This means the appropriate action must be taken with respect to certify whether denial or suspension whenever the existence of an active substance abuse disorder becomes an official attention to the railroad, with the exception disclosed below. The paragraph D also provides mechanisms for the employee voluntary self-refer to the substance abuse counseling treatment. Paragraph E addresses the conducting constitution of violation of statute 219-109 and 219-102 of the Alcohol Drug Regulation statute. In 219-101 prohibits the employee of the remaining of the duty of the covered with service while using, possessing, or being under the influence of impaired alcohol or controlled substance with a blood alcohol concentration of 0.4 or more. An employee may also not use the alcohol either from the hours of reporting from covered service or after receiving notice report for covered services, which is less. This is the conduct specifically directly threatens safety in the way that is wholly unacceptably, regardless of the genesis, regardless of whether it has occurred previously. It is in more extreme forms, such as conduct is punishable as felony under the criminal laws of the United States, Title 18 U.S. Standard Code 341, attempt sequence and number of states. Section 219-101-102 prohibits the controlled substance of covered employees at any time of office, on or off duty, except for under the exception for approved medical use. Abuse of marijuana, cocaine, amphetamines, and other controlled substances pose unacceptable risk to safety. Under the drug alcohol regulations, whether in a violation of 219-101 or 219-102, it is established based on the authorized mandated chemical testing that the employee must be removed from service and may not return after the SAP evaluation. Any of the need treatment negative return of to duty is the subject to the following of the test as required in 219-104. The structure suggests an absolute minimum for the action when a conductor is determined to have violated one of these prohibitions. Consider the need of the general specific deterrence with respect to the future unsafe conduct. Additional action should be permissive in severity of the violation whether the same individual has prior violations. Other key consideration: evaluation of the conduct, the appropriate response of the duration of the retrospective review, the rules and requires the railroad to consider the conduct that occurred in the period 60 consecutive months prior to the review. This is the same period provided in the rule of the maximum period of ineligibility for certification following the repeated alcohol drug violations, and same period used in Part 240. Use of the 5-year cycle reflects an anecdotal experience in the railroad industry, indicating the conduct committed is much more than 5 years before may tend to predict the future alcohol and drug abuse behaviors. As recognizing the reality of the most individual violations are probably not detected, it also reflects certain confidence and resiliency of human nature, i.e. a responsibility expectation that a person who remains in compliance for the period of the time will not again be found in violation. Of course, the railroads retains the flexibility to consider prior conduct, including conduct more than 5 years prior, in determining whether they will hire as a conductor. Interested parties should note that more than the conduct violated for the FRA prescription of the alcohol drug needs not occur while the person is serving in the capacity of a conductor in order to be considered. For instance, the employee was violated 219-101 while working as a brakeman and then sought to conductor certification 6 months later. Under the provisions prescribed below, would not be currently eligible for certification. The same true under Part 240. Any employee who violates 219-101 as while working as a brakeman, they seek locomotive engineering certification 6 months later would not be eligible for certification at all. At the time, the railroad responsibility would not be limited to periodic recertification. This rule requires review of certification status for any of the conduct violation of 219-101, 219-101 and 219-102. Rules require to determine ineligibility for the period of 9 months for the initial violation of 219-101 and the perils of 9-month disqualification in 240-119C430. The FRA does not believe the conductor should be able to seek the shelter of the collective bargaining agreement or more lenient company policy in case of the clear on-the-job violation insofar that the federal eligibility to serve as a conductor is concerned. Specifically, a period of ineligibility serves in the interest of deterrence while giving the further encouragement to the co-workers to deal with the problem. The forward is detected management in order to preserve encourage co-workers. Referrals to 9-month can only be waived in the case of the qualifying co-worker report. See 219-405. The FRA believes the distinction of the treatment is warranted in the strong inducement of the participation because the co-worker referral programs to help them identify troubled employees prior to these employees getting into the incidents or accidents. Strong inducements to refer the co-worker. The worthy goal is made to contribute to the reduction in the accidents incidences. Although FRA does not know how many actual co-workers report may be generated, the intended result will be served as an atmosphere of intolerance for the drug and alcohol abuse behavior and reinforcing the workplace, or violators know that they may be reported by their colleagues if they are reported for duty impaired. In the case of the second violation of 219-101, the conductor will be ineligible for a period of 5 years given the railroad employment practices commitment to alcohol drug compliancy. It is likely that, of course, the individual is so situated may also be permanently dismissed from the employment. However, it is important that the employee railroad also follow through the revoking the certificate under this rule is the conductor conduct not to go to work for another railroad within a 5-year period using an unexpired certificate issued by First Railroad at the basis of certification. These sanctions mirror the sanctions of 240-119. Under this rule, one violation of 219-102 within 5 years window with requiring only temporary suspension and minimum response described in 242-115F. Referral for evaluation treatment is necessary. Never return to duty test on appropriate follow-up and these parallels to the approach of the taken in Part 240 reflects the FRA's which note undercut the therapeutical approach of the drug abuse employed with the many railroads. This approach permits the first time the positive drug tests to be handled in a non-punitive manner that concentrates on remediation of the underlying substance abuse problem, avoids the adversely process associated with investigation, grievances, arbitration under the Railway Labor Act and collective bargaining agreements. The second violation of 219-102 would subject the employee to a mandatory 2-year of ineligibility, or a third violation within 5 years would lead to a 5-year period of ineligibility. The rule also addresses the statute 219-101 and 219-102, a combination of the person violating 219-101 after 219-102 violation would be ineligible for 3 years. The same would be true for the reverse sequence. Refusal to participate in the chemical testing are treated as if they were positive. Refusal to provide breath or body fluid sample for the testing under the requirements of 49 CFR Part 219 when instructed to do so by a railroad representative are treated for the purpose of ineligibility under the section in the same manner of the violation of 219-101. In the case, refusal to provide a breath sample, a blood specimen, or mandatory post-accident toxicological testing to the 219-102. In the case of the refusal to provide a urine specimen test Interested parties should note that the Title 49 CFR 40 Subpart 1 provides a medical condition under the individual failure to provide any sufficient sample is not deemed refusable. Moreover, the Subpart G FRA controls the alcohol drug use of regulation exposed the covered employee from the compliance with the requirement to participate in the random alcohol drug casing, in this case documented medical or family emergency. See Title 49 CFR 219.603 and 219.609. Those provisions are incorporated in this rule under the refuse. Interested parties should also note that the person covered in Title 49 CFR Part 219 refuses to provide a breath or bodily fluid specimen or specimens required to be the railroad under the mandatory provisions of Title 49 CFR Part 219, then the railroad apart from any of these sections it takes under 242 is required to remove the person from the covered services, disqualify the person from working in covered service for 9 months. See 49 CFR 219.104 and 219.107. See also 49 CFR 219 Subpart H and 4191 and 4261. Paragraph 242 1150E 44B has been modified to the final rule, removing the sub situations and adding the phrase for alcohol testing. Those modifications are simply clarifications to confirm the final rule to the provision of this part. 19. Paragraph F describes the conditions under which the employee must be certified, recertified after the determination that recertification should be denied and suspended, revoked due to the violation of Part 219.101 and 219.102. Alcohol drug relations. These conditions are derived with the condition of 241.19. D. Closely parallel return duty provision for the alcohol drug rule. Interested parties should note that the 214.115 F13 has been clarified at the final rule with respect to alcohol concentration to more accurately reflect the provisions of the FRA's alcohol drug rule. Interested parties should also note the regulation does not require compensation of the employee for the time spent in testing, which is condition presented to the retention of the certificate, but the issue of the compensation would ultimately be resolved by the reference to collective bargaining agreement, other terms and conditions employment under the Railway Labor Act. Moreover, the railroad, this intended withdrawal and its additional certification must afford the conductor a hearing procedure providing with statute 242-407 if the conductor does not waive his or her right to hearing. Paragraph G ensures that the conductor, likely another covered employee, can self-refer to the treatment under the alcohol drug rule before the detected violation of the alcohol drug prohibition would be entitled to confidential handling of the referral subsequent treatment. This means the railroad would not normally receive the notice of the drug alcohol counselor of any substance abuse disorder identified as such a result of voluntary self-referral under the Title 49 CFR 219.403. However, the paragraph also requires the railroad policy must, rather than may, provided the confidentiality is waived and the conductor fails to participate successfully in the treatment is directed by the drug alcohol counseling pursuant to Title 49 CFR 219.403. The extent of the railroad must receive the notice of that the employee has the active substance abuse disorder, so the appropriate certification action can be taken. The effect of the provision is the certain certification status of this conductor who seeks the help and cooperates in the treatment and will not be affected unless the conductor fails to follow through. Section 242.117 Vision and Hearing Acuity.